take you back to that breaking news coming from New York. The Attorney General suing former President Donald Trump and his 3 adult children. Let's listen into a news conference.
That the information in the statement would be relied upon by banks and insurers. Mr. Trump and Mr. Weisselberg would meet to review and approve the final statement every year. Mr. Trump made known through Alan Weisselberg that he wanted his net worth reflected on the statements to increase, a desire Mr. Weisselberg and others carried out year after year in their fraudulent preparation of the statements. And when asked about these meetings under oath as part of our deposition, both men, Mr. Trump and Mr. Weisselberg, invoked their Fifth Amendment privilege against self-incrimination, and they refused to answer. When asked under oath if he, Mr. Trump, continued to review and approve the statements after becoming President of the United States in 2017, Mr. Trump, again, invoked his Fifth Amendment privilege and refused to answer. Over the course of our investigation, we found that Mr. Trump, his children, the Trump Organization, created and used more than 200 false and misleading asset valuations on his statement of financial condition over that 10-year period. They issued statements that were in clear violation of general accepted principles in the general accounting principles in the United States, despite representing that these statements were prepared in accordance with these principles. Some of the common tactics they used include representing that Mr. Trump had cash on hand that he did not have, ignoring critical restrictions that would significantly impact property values when setting valuations, changing the methodology used to value properties from year to year without reason or notice, and using vastly different methods to value different properties even in the same year, and including tangible items such as brand premiums, the Trump premium, when calculating an asset's value, despite the fact that they ignored the advice of outside professionals. They also ignored the advice and appraisals of outside professionals, despite claiming those individuals provided certain figures. For example, they received a series of bank-ordered appraisals for the commercial property at 40 Wall Street in New York City that calculated the value of the property at $200 million as of August 2010 and $220 million as of November 2012. Yet, in his 2011 statement, Mr. Trump listed 40 Wall Street with a value of $524 million, which increased to $530 million over the next 2 years, more than twice the value calculated by the professionals. Even more egregious, the $500 million plus valuation was attributed to information from the appraiser who valued the building at just over $200 million. Another deceptive strategy they employed was to use objectively false numbers to calculate property values. Take Mr. Trump's triplex. You know, the triplex apartment in Trump Tower on Fifth Avenue? Mr. Trump represented that his apartment spanned more than 30,000 square feet, which was the basis for valuing the apartment. In reality, the apartment had an area of less than 11,000 square feet, something that Mr. Trump was well aware of. And based on that inflated square footage, the value of the apartment in 2015 and 2016 was $327 million. To this date, no apartment in New York City has ever sold for close to that amount. Tripling the size of the apartment for purposes of the valuation was intentional and deliberate fraud, not an honest mistake. Mr. Trump was intimately familiar with the layout of both the building and the apartment, having personally overseen the construction of both. Despite his sworn testimony before invoking his Fifth Amendment privilege, Mr. Weisselberg conceded that using the false square footage improperly inflated the value of the apartment almost threefold. Mr. Weisselberg admitted that this amounted to an overstatement of, give or take, $200 million. Misrepresenting the size of the apartment was only one of the many ways that Mr. Trump intentionally misvalued his asset for the purposes of increasing his net worth and inducing banks to offer more favorable terms. Mr. Trump also routinely ignored legal restrictions on development rights and marketability on properties that would significantly decrease property values. For example, let's take Trump Park Avenue in New York. This building contains both commercial and residential space. The unsold residential condo units owned by Mr. Trump and the Trump Organization represented the lion's share of the reported value for this property. Mr. Trump and his children intentionally ignored legal restrictions on some of the units that would have drastically changed the valuation. Specifically, the 12 of those units were actually rent-stabilized apartments. A professional appraiser valued those 12 units at around $750,000, noting that the rent-stabilized units cannot be marketed as individual units for sale because the current tenants cannot be forced to leave. Despite this professional valuation, and Mr. Trump knowing full well the legal restrictions the 12 rent-stabilized units were valued, he valued them collectively on his statements at $49 million. That is about 65 times the appraised valuation. Mr. Trump also blatantly ignored legal restrictions at Mar-a-Lago. Mar-a-Lago was valued on the false premise that it sat on unrestricted property and could be developed for residential use. However, Mr. Trump knew that Mar-a-Lago was subject to a host of onerous restrictions and limitations. Mr. Trump himself signed deeds sharply restricting changes to the property and donating his residential development rights in an effort to get a tax deduction and later to lower his property taxes on the property. The deeds also require Mr. Trump to donate over 23% of Mar-a-Lago's value to the Historic Trust for Historic Preservation if he ever sold it.
Well, that is the New York Attorney General giving a press conference there in New York regarding the suing of former President Donald Trump and his 3 adult children, alleging business fraud.